It should be cited regularly, and I would encourage all the plaintiffs' counsel to become familiar with it.
The Weekly Friedman, your source for the most essential information in the default industry. With your host, Adam Friedman.
Today I'm joined by Senior Appellate Counsel and regular on the Weekly Friedman, one of our most popular guests, Stephen Vargas. Steve, how's it going?
Great, nice to be back. I appreciate the intro.
You got it. And shocking to no one, we're talking about FAPA again, as always.
I am back again to talk about FAPA. That is like clockwork.
All right, so today we're talking about Citibank v. Inga. Let's jump right in. What are the key points here? What are the key topics and legal principles involved?
I'm going to go straight with the law school term. I'm going to go with the holding. This is a case where the Queens County Supreme Court, Justice Leverett, in a foreclosure action, held that the prior deceleration letter, an adjudication regarding the validity of a prior deceleration letter in connection with either a prior foreclosure or prior quiet title case, has res judicata effect as to whether the acceleration of the mortgage was revoked and statute of limitations reset, irrespective of the FAPA amendments, CPLR 203H, and even potentially CPLR 217E, which govern unilateral deceleration and how deceleration can occur, if at all.
Let's slow this down for the non-lawyers in the room, right? Not everybody went to law school. What does res judicata mean?
Res judicata is a common law doctrine that you see in federal and state court decisions. You see a lot of discussion from it in the U.S. Supreme Court even, as well as the New York High Appellate Courts. It means that there's a ruling from a court that has a, quote, final effect regarding an issue of fact or law. And here, the issue of law was, A, whether the statute of limitations expired, and there was an interplay between that, and the answer to that was dependent on whether the deceleration letter was valid if it was sent before FAPA became law.
So in essence, the court here is saying, I think it was a 2021 case.
It was.
From Justice Butler. So the court here is saying, irrespective of your arguments, Justice Butler made a decision a couple of years ago, and that decision stands.
Correct. That's exactly what happened. The court is finding that the 2021 decision from Judge Butler in Queens County issued a ruling and said the deceleration letter was valid and that has res judicata effect. It's binding. There was a res judicata effect with respect to the deceleration letter.
This all sounds so obvious. It's interesting in light of how FAPA operates because the big headline on FAPA, right, is that it's retroactive. So now, are we saying in this court it's retroactive unless there's a prior decision?
Essentially, that's what the judge is saying. In the decision, the judge was very careful to note that the appellate courts, the intermediate appellate courts, as of now, and it hasn't changed since this decision came out in mid-January, they've been applying the FAPA amendments retroactively, and they have been rejecting constitutional challenges. So in this case, the plaintiff made several arguments, leading with a res judicata argument based on the common law, and then arguing about the scope of retroactivity and then any sort of constitutional challenges regarding retroactivity. The trial court judge noted that other courts, including the appellate courts, have found FAPA can be validly applied retroactively. However, there's a carve-out, so to speak, in a situation where the common law res judicata doctrine applies, which is what applied here. And in that instance, FAPA, a legislative amendment, cannot be used to sort of supersede or trump a court decision that it has final effect. And in this case, there's a ruling from Judge Butler in 2021. Judge Butler is another Queens County Supreme Court justice, dismissing a borrower's quiet title case, which was brought based on a claim the statute of limitations ran. Judge Butler said, no, it did not, because the bank sent a deceleration letter within the statute of limitations that validly reset the SOL. Borrower tried to rely, or in this case, a property owner, actually, the corporate entity, tried to argue that FAPA nullified that ruling. The plaintiff argued that res judicata cannot be trumped by subsequent legislation. Court agreed with the plaintiff in that instance, said the res judicata doctrine is extremely powerful and even legislative amendments cannot overrule it.
It makes sense here because there was a prior decision specifically ruling on the SOL.
It was specific on that issue, exactly. The quiet title case, the outcome of the quiet title case hinged exclusively on whether or not the statute of limitations expired. That was the only issue before the court in that case, and the judge ruled it did not expire.
How does this work with judgments, though? Because a judgment is a decision that the foreclosure was valid, right? Does that have res judicata protection?
It should. As far as the finality of a judgment, what does that require? Because that's kind of step one. It requires the judgment to have been entered and the time to appeal from the judgment has run, meaning A, the judgment was appealed and there was an appellate ruling affirming the judgment, or B, the judgment was not appealed and the time to do so has elapsed. So in that sense, a judgment in virtually all contexts is final. Now, the FAPA statute itself, Section 10, the implementing clause, has language insinuating that the FAPA amendments may have been intended to potentially circumvent the finality of a judgment, or at least it's ambiguous. It doesn't get into it one or the other, but it does say the act can be applied until a judgment has been enforced. What enforced means, whether it means scheduling a sale or actually holding a sale, different courts have issued rulings on that issue. But a decision like this, according to Judge Leverett would presumably say a judgment of foreclosure that's final would preclude subsequent FAPA challenges. We're waiting for an appellate court in the first, second, or third departments to rule on that. There was an appellate ruling in the fourth department that I'm going to plug because it's one of our appeals. We discussed it on a Weekly Friedman a few weeks ago, Florida Notes versus the State of Paul, in which the fourth department, in a case of first impression, said after the time to appeal from a judgment is run, you can't try to litigate based on a change of law relying on a FAPA amendment. So I think that's a pretty powerful tool, the Estate of Paul case. This case is in harmony with the Estate of Paul. But like I said, we haven't seen appellate rulings from the first, second, or third departments about how a final judgment, what the effect it has in relation to FAPA. But according to this, the bank would be safe, so to speak. Its judgment would be its own property, and the judgment would be secure.
Okay, look, so obviously it's not an appellate decision. This is a trial court decision. How important is this?
Given the lack of case law on the res judicata issue as it relates to the FAPA amendments, I think it's very important. As you said, it's not an appellate decision, so I can only go far as to say, the value it has. It's not binding on any court. It's certainly persuasive, though, because it's well-reasoned. It's very well written. Judge Leverett did a great job articulating why res judicata applies here. I think there's a wealth of decisional law from the federal and the state courts, particularly the U.S. Supreme Court, which is the law of the land regarding something like this, like a common law doctrine, that this is consistent with. Res judicata doctrine, in numerous contexts with the statutory amendments, has not been abrogated in any way. If there's an order or judgment that has res judicata effect, that's the end of the issue. Challenges based on legislative amendments in other contexts have failed. So I'm cautiously optimistic that in the FAPA context, we'll see the same outcome. But it's something that the plaintiff's bar really needs to be citing. I've talked about this in the past, going back, when we talked about FAPA almost a year ago. Getting good decisions on issues like this, particularly when the appellate courts are narrowing down the arguments that plaintiffs can make regarding why FAPA shouldn't be applied retroactively. Given what we're seeing, some negative decisions out of the intermediate appellate courts, we have to make the most of a decision like this. It's a favorable trial court decision without any appellate precedent to the contrary. It's well written. Plaintiffs should be relying on it. It was reported, just to illustrate the impact, judges can submit decisions for reporting, meaning it gets published. Not all decisions get published in state trial courts. Whoever submitted it for publication, the court reporting service, whether it was the judge or a party, court reporting service found this decision important enough to publish it. And for anyone who follows how many cases get published every day, maybe 20 a day across the states. You're talking out of all the trial court counties, one in every few counties gets published every day. So this was published. It should be cited regularly. And I would encourage all the plaintiffs' counsel to become familiar with it because it really could help potentially win a case.
This case highlights the critical intersection of constitutional due process rights, res judicata, and the application of new legislation in foreclosure litigation. Justice Leverett's decision reinforces the principle that final judgments must be respected, even in the face of subsequent legislative changes, providing a significant safeguard for note holders navigating the complexities of FAPA. Thanks for joining Stephen Vargas and I on the Weekly Friedman, your source for the most essential information in the default industry. Looking forward to seeing you next.